Sir William Seo.
Mr. Speaker, given this is an Auckland Issues Bill, can I, with your indulgence, just take this opportunity to acknowledge, firstly, the death of John Alomo and convey to his wife, their extended family, our condolences, and just acknowledge the fact that Jonah was a great friend of Pacific youth, and particularly in South Auckland. And he will be sorely missed by many, not just in New Zealand, but throughout the world. I now want to come to the bill, sir, and just because we are amending the 2010 Auckland Transitions Bill, I want to just reflect on that for the sake of the House, and particularly for those who weren't involved in the initial debates in 2010. Members may recall that when we debated the Local Government Auckland Transition Provisions Bill in 2010, that included two other major and significant bills: the Local Government Tamaki Makaurau Reorganisation Amendment Bill and the Local Government Auckland Council Amendment Bill. In fact, sir, what happened was, I think the House concentrated on the two significant bills and we paid little attention to the Auckland Transition Bill. It almost appears, sir, that a pattern has emerged where when this government is intending to hide things, they'll include it with other significant bills so that nobody pays attention. People may recall that when public consultation went out on those three principal bills, it was during the Christmas period and people didn't have a lot of time to make submissions on it. Today, sir, I have to say, I think Aucklanders will be equally sad that again we are debating issues that affect them without the privilege or without the benefit of having their experience, their expertise, in fact, their criticism of what this government is doing. I want to say, sir, that side paints as if they are doing Aucklanders a favour. They're saying that this bill will allow Aucklanders to have a say. Well, Aucklanders will have a say. What this bill is about, it's going to fix some mistakes that they've made, mistakes that they failed to do as a result of the pattern that they have created for themselves of rushing through things when they don't want the general public to have a view or to share a view in terms of what they are doing. And again, sir, you may recall that during that whole Auckland Super City debate, Aucklanders were outraged at the way that this government collapsed the whole process and were determined to corporatise that whole Auckland Super City. And that's what we're seeing. In fact, the 2010 Local Government Auckland Transitional Bill, what it also changed, sir, was it enabled the hearings panel to be appointed by the minister rather than what existed at that particular time where councils appointed hearings commissioners. If we had councils continuing to appoint hearing commissioners, we wouldn't be in this situation now of again trying to fix the mistake that they made. They made those mistakes, and it's amazing, sir, that other than the people of Aucklanders, and this government continues to think that they're doing okay, that they are smart, that they know what they're doing. The reality is we have a very unique select committee process, sir, where all legislation ought to go through that particular process, because that gives us the benefit, sir, of enabling the public, enabling those with deep experiences, those with expertise in these particular matters, and for us to have the benefit of that experience, of that knowledge. And sadly, sir, again, this government just doesn't seem to have learnt their mistakes, that rushing through things will inevitably end up where mistakes are made. And here's the mistake, sir. I want to point out what we're clarifying. We're clarifying that the hearings panel can hold hearing sessions concurrently. And so here's the hearings panel who have been holding hearings from the public since September this year, and this bill's now saying you can actually do that legally. and so here's another mistake that fixing. So it allows the hearings panel to appoint an additional chairperson that can chair concurrent hearings when the chairperson is not available because they're chairing the other concurrent hearing. I suspect that the panel are already doing that. And they wouldn't have this mistake, sir, if they hadn't rushed through in the original 2010 determined to corporatize the whole Auckland region for the sake of trying to control those assets and allowed the council to appoint the hearings commissioner. Here's another mistake that this bill is designed to do. It will validate any hearing sessions that were held concurrently prior to this clarification. Another mistake, it validates the 28th of February 2014 as the closing date for submissions on the unitary plan. And it validates that any submission received between the 14th of January 2014 and the 28th February 2014 is acceptable as if they were received within the statutory time frame for submission. And another important mistake that we're having to fix as a result of this bill is the error in the drafting of the Principal Act relating to procedural requirements for the filing of appeals on questions in law with the High Court. So I don't have any problems with appointing additional hearing members, because if you look, sir, if we consider the work that they are having to undertake, they are having to consider over 9,000 submissions. And I understand, based on what's on the website, the Auckland Unitary Plan and Hearings Plan, those 9,000 submissions are raising around 100,000 points concerning possible changes to the plan. There is no doubt in my mind, sir, and in many of my colleagues, that the unitary plan for Auckland City is an important plan. But we said right at the outset that it was flawed in many ways. It was flawed because whilst this government would talk the rhetoric about the principle of subsidiarity, in actual fact, sir, after some years of experience with the Auckland Council now, we now know that the structure has designed exactly as we predicted in those earlier debates of 2010. The public will have difficulty being involved in the decision making because this hearings panel, sir, is a professional hearings panel of people who are well versed in the areas of unitary planning. And so it is a professional panel. When this government says that this will give the public the opportunity of hearing, they already have those rights. This is predominantly about making the mistakes of fixing the mistakes that this government made in the original bill. I want to say, sir, that when we went through the 2010 debate, many people in Auckland all said that the way that the Auckland Super City was structured with its independent CCOs would ultimately divide the community from fully participating in our democratic processes that we have become accustomed to and which we in New Zealand value. I would have hoped, sir, that this government would have learnt their lessons from the consistent mistakes they have made with the various amendments to the principal acts of that period. But they haven't, sir. And I think and I hope that Aucklanders listening to this particular debate will recognise once and for all that that super city structure wasn't set up to allow more democracy. It was set up predominantly for this government to control that city and control its direction, control its assets, in the same way it now appoints the hearings panel. And I'm hopeful, sir, that come next local body election in 2016, we can get some good people on that council that can stand up that can stand up and tell this government where to go.
Ko Nick